Hi everyone, we are getting started with our review for Module 5, which covers chapters 13, 14, and 15. So let's get started. Chapter 13 deals with legal capacity to contract. This includes two different concepts. First, whether the person has some type of a mental illness or is a special category of person who would not be of age, for example, someone who is considered to be an infant or under the age of majority. These folks have issues that come up with regard to contracting. We'll talk about those in a second. And the second group deals with contracts that are illegal. Some contracts are to commit a crime, some contracts are against public policy, and for those reasons they are deemed to be illegal and therefore would not be enforceable. When we talk about legal capacity to contract, think about instances where a person may not really have the ability to form what is required under the offer and the acceptance. So remember, under the offer, it is a present serious intention to be bound. If a person does not have the mental capacity to truly do that, if they are not really understanding what they are selling, for example, they would not have the capacity to enter into a contract. Additionally, you might have someone who may not be able to voluntarily consent, so the acceptance may be lacking as well. There are people with mental illness, I should say, are treated differently in the law depending on their status. So if you have a person whose family, for example, has gone to court and deemed this person to be mentally incompetent, that means they have been adjudicated by a court to be that way, and as a matter of law, they are not allowed to enter into contracts. We call those void. So anyone who has been adjudicated or declared incompetent by a court cannot enter into a contract. Those folks who fall into the category of having some type of mental capacity issue but have not been declared by a court to be incompetent, they would fall under the other category. We distinguish between the two because one has a void right and one has a voidable right. And the void right is not really a right at all, but their contracts are void as a matter of law. That means they can't enter into them if they've been adjudicated mentally ill. And if a person has not been adjudicated that way, their right is voidable. And the distinction is an important one because it is their option. The person who suffers from the mental incapacity, they have the option of whether they want to enforce that contract or they want to disaffirm it and walk away from all obligations. So that's a really big difference, and it's one that you should take note of and understand that. The same happens with minors. Minors also have a voidable right. So minors are a person who is under the age of majority. In most states, that's 18. You would need to check that with your state to make sure that you understand what the age of majority is. If a person makes a contract, who is a minor, makes a contract under the age of consent, that person, under the age of majority, that person has a voidable right, which means the minor has only until a reasonable time upon reaching the age of majority to either disaffirm the contract or to be bound by it. If a person who is a minor decides he or she wants to be bound by that contract, we call that ratification. If the person wants to get out of it, we call that disaffirmance. And we studied on the discussion board that there are times when a person may not have an option here. They may end up taking some of the goods and ruining them, and they may end up misrepresenting age. Every state's a little bit different on this area of the law, so you do have to check with that. Any person who is a minor who is emancipated, a person who has broken off and is taking care of themselves legally, that person has a different status in the law. As a practical matter, the law does not want to encourage adults from contracting with minors because minors don't have the same understanding in the marketplace. They don't have the same sophistication when it comes to bargaining. So the law does not want them, for the most part, entering into contracts. That's why anytime you see something, you go to buy something, you have to click a box to, certify that you are 18 years or older, because merchants know the law and they know that they can lose out if they contract with minors because minors can disaffirm those contracts. Okay, so anyone who is an emancipated minor, that party has the right that party is bound by contracts for necessaries, and a necessary is defined as food, clothing, shelter, something that you absolutely need for your survival. So if you rent an apartment, for example, and you are an emancipated minor, you would still be held liable for that lease agreement. However, a minor only owes the reasonable value of the goods or services, does not owe the full contract price. Sometimes that can be a big difference. Sometimes it can be a lot more money for what someone is charging rather than the actual reasonable value of the goods or the services. Okay, and then the second set of second part of that chapter deals with illegal contracts. Any type of an illegal contract is going to be void. A contract to commit a crime, for example, a contract to commit a tort. If you say, I want you to, go punch somebody and I'll pay you $500 for that, that's a contract to commit a crime and a tort at the same time. And those are against the law. Contracts that are against public policy are also void. If there is an embargo, or say the United States will not enter into any type of contracts with a foreign government. If you then make a contract with that foreign government, it would be deemed void because of the embargo. All right, so that's basically the material for Chapter 13. Chapter 14 deals with genuine assent. And these are ways, for lack of a better way of saying it, these are defenses to contract formation, because there was some problem with the meeting of the minds. In order for contracts to be valid, you have to have both parties pretty much on the same page. And they have to be agreeing to the same thing, and those agreements have to be done voluntarily. Sometimes the agreements are entered into, but there is that lacking of genuine assent or the voluntariness that's necessary for contract formation. So we look at those, and we may have something that pops up called mistake. Remember, you need to have a bilateral mistake of fact in order for the contract to be set aside. So both parties have to be mistaken about an essential element of a contract. Let me give you an example. Suppose that I go to a dog breeder and I pick out a dog and I say I really want a dog so that I can become a breeder myself. So I know I want a female dog and I want to make sure that she's able to breed. I'm sold a dog that the other party believes is a female dog that can breed other dogs. I get her home and we realize later that she is sterile, she's barren. So this dog cannot reproduce. That was an essential element of that contract, right? And if I and the other party were both mistaken about that, we can set aside that contract based upon bilateral or mutual mistake. If you have a mistake of law, that's not generally an excuse. And if you have a unilateral mistake where only one party is mistaken and not the other, that also is not a basis to set aside the contract. If you have a mistake of value, likewise, that also will not be enough to set aside the contract. Mistake of value just means that you believe it's worth one thing and the other party believes it's worth another. There's an example in the back of the textbook, back of the chapter on this topic. And in that example, a little girl finds a stone and she thinks it's just like a rock and she sells it. It turns out to be a diamond. So if you are mistaken, the other party knew it was a diamond and bought it for like $9, she made a mistake, right? She mistakenly thought it was a rock instead of a diamond, so that could be a unilateral mistake of fact, but it also could be a mistake of value. Maybe you find something at a yard sale, you know what it is, you don't really have an idea of what it's worth, and you sell it. You're mistaken about how valuable the item is, but that's your loss. Other ones we have are duress. Duress is threatening somebody by force or threat of force against you or family members. If you don't sign this, I will shoot you. That's duress. It's physical force against you or someone else. You can also have economic duress, and economic duress means that you're going to withhold money. You are going to stop paying a person or just basically freeze their bank account or something. Undue influence is when somebody there's a special relationship of trust between two parties, such that there's one person who's more dominant than the other, a caretaker and an invalid, for example, and the caretaker uses that position of authority to exert undue influence over the other party, the submissive party. And maybe the caretaker makes the other person sign the deed to the house over. It's not voluntary. It's not done out of free will. It's done because you're going to withhold my care. You're not going to give me my pills. You're not going to take care of me if I don't do this. The last one in that chapter is about unconscionability. Unconscionability just means that the terms are really one-sided, and it really shocks the conscience of the court. If things are so one-sided and unfair in favor of one party and so, so against the other party, the court may say that's unenforceable, it's unacceptable. Contracts like that, think about the interest that are charged at like Rent-A-Cent and places like that. Courts don't like that. And Chapter 15. We did not spend a lot of time on Chapter 15. I did not ask you a lot of questions about that. It's really kind of tough. 15 deals with contracts. Oh, not 15, I'm sorry. I was thinking of 16. But contracts that have to be in writing to be enforceable. Chapter 15. There are 5 types, and that's basically all you need to know, are the 5 different kinds of contracts that have to be in writing to be enforceable. You have contracts in support of marriage. That's really just a prenuptial or an antinuptial agreement. Contracts for the sale or transfer of an interest in real estate, because they're really big and they're really important. These types of contracts have to be in writing. Contracts that cannot be performed within 1 year. So if you got an employment offer and it was for a 5-year employment in a company, you'd have to have that in writing. Collateral promises, which are where you're signing on behalf of someone else, maybe a car loan or something like that, that has to be in writing to be enforceable. And the last set, contracts for the sale of goods in excess of $500. We'll talk more about that when we talk about the section in Module 7 about the UCC. Basically, that's it. Those are your contracts that have to be in writing to be enforceable. If you have any questions, please just post them in class and we'll go on to Module 6.